Good morning, Your Honors. The matter before the court this morning is the case entitled Clayton E. Butler versus Town of Westmore, case number 24 AP 115. Representing the appellant, Clayton E. Butler, is Paul Briere. Representing the appellee, Town of Westmore, is Mary Kate Kelly.
Thanks very much. Good morning, counsel. We'll hear from the appellant first, of course. Please introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. My name is Paul Briere, and I represent the appellant, Mr. Clayton Butler.
Thank you.
All right, thank you, and may it please the court. This court should reverse the trial court's decision for two main reasons. First, Vermont case law shows that the town's personnel policy is ambiguous, and second, whether Mr. Butler's resignation was involuntary is disputed. These issues and numerous others in this case are questions for a jury. Starting with the town's policy, there are two lines of cases that show that it's ambiguous. One line, which includes Ross v. Times Mirror and Green versus Vermont Country Store. In that line, employment was held to be at will because the policies in those cases did not have progressive discipline procedures. In contrast, the other line of cases, which includes Farnham, Benoit, Taylor, and Dillon, the policies in those cases did include written progressive discipline procedures, and those policies were held to be ambiguous, even though they also included a stated discretion to bypass, as the policy does in this case. There's an on-point Superior Court decision, Dalto versus Factory Point National Bank, which provides a good roadmap for applying the Farnham cases to the town's policy and practices in this case. The Farnham cases in Dalto show that a jury should decide whether there was an implied contract, and if so, whether Mr. Butler should have been afforded progressive discipline instead of a 2-week unpaid suspension. Moving on to whether Mr. Butler involuntarily resigned, there's a dispute over the effective date of his notice. That effective date turns on what was said during the April 17th executive session. In that session, Mr. Butler said he was giving 2 weeks notice, and he confirmed that by asking whether he could work through that notice after completing his 2-week suspension. To the extent that's disputed, it is a question for the jury to decide. Second, there are key disputes as to whether the select board took purposeful actions during those 2 weeks to force Mr. Butler's resignation. These include, when did the town instruct the select board not to talk with Mr. Butler after telling him he had time to think about resigning? And when did the select board decide to reject any request Mr. Butler made to return to work? A jury should also answer those questions. Next, regarding Mr. Butler's tortious interference claim, an important disputed action for that claim is whether Mr. Heislip directed Mr. Osier, his employee, his supervisee, to make audio recordings and photos of Mr. Butler without his knowledge. And if a jury finds that he did, then Mr. Heislip's conduct clearly falls outside the scope of his authority. Those activities are not authorized by the town policy, and the select board never voted to authorize them. Likewise, whether the select board members' actions show malice is also a question for the jury pursuant to Payne v. Rosendahl. Now, regarding section 901 parentheses A of Title 24, that this court stated in Holmberg v. Brent that section 901A, quote, amounts to an assumption of the officer's liability. In the context of that case, section 901A's mandate to bring actions against municipal officers in the name of the town does not distinguish between conduct within or without the officer's scope of authority or with or without malice. So precedent and 901A instruct that Mr. Butler's tortious interference claim against the select board members had to be brought against the town, and that the underlying factual disputes are questions for a jury. Turning to due process, if a jury decides that Mr. Butler has a property interest through an implied contract, then his rights were violated when the town suspended him before he resigned, without notice and an opportunity to challenge his discipline. They violated his due process rights when they relied in part on the unauthorized recordings to discipline him because he didn't have a chance to respond to them. And they finally violated them when they decided to terminate him, but deprived him of an opportunity to appeal that decision.
You have 1 minute, counsel.
Okay. And so, and I'd actually like to reserve 1 minute for rebuttal. So that concludes my initial argument. Thank you.
Okay, thank you. We'll turn to counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. May it please the court, my name is Mary Kate Kelly. I represent the town of Westmore.
Thank you.
It's undisputed that on April 17, 2019, in response to a disciplinary memorandum with a 2-week unpaid suspension, Mr. Butler gave a 2-week notice. Mr. Butler's own testimony is clear on this point. He told the select board that if they believed what was in the disciplinary memorandum, they could take his signature on the memorandum as his 2-week notice. He signed the memorandum and handed it back to the select board. As he testified, the town obviously believed what was in the memorandum. Mr. Butler fails to present any facts to support a finding of involuntary resignation. The only Vermont case analyzing the issue is in Ray Bushy, and that case required the employee to seek to withdraw their resignation to test the claim of involuntary resignation. Mr. Butler here made one request to the select board to return to work. He attached conditions to his return to work in an attempt to negotiate a change in his position, reducing his supervisory responsibilities and refusing to work with another employee. Under federal case law, cases finding an involuntary resignation make clear that a 2-week unpaid suspension is a voluntary resignation. Unlike federal cases finding involuntary resignation, here the town did not threaten to terminate Mr. Butler if he did not resign, and there's no fundamental right at issue and no issue related to union activities. Mr. Butler chose to resign.
Are any of those facts in dispute in this case about the voluntary resignation?
Plaintiff or Mr. Butler contends that resignation was involuntary.
And but in the undisputed facts, was it a question that said that he was forced in some way to resign?
He claims he was forced to resign because of activities by that Mr. Hepsla, as part of his returning to work, Mr. Heslop was going to be his supervisor. So he said that would be intolerable. And there's no case law to support having even a supervisor that is not supportive of a particular employee. There's no case law to support having that person supervise an employee creates an intolerable work situation. If the court agrees with the trial court that Mr. Butler resigned voluntarily and was not constructively discharged, his contracts and due process claims fail. There's no need to consider whether his at-will employment was modified. His contract claims also fail in that his at-will employment was not modified by policy or practice. Acknowledgement in the of the personnel policy disclaims a contractual relationship and asserts employment is at will. The policy itself reiterates it does not constitute a contract of employment and states 3 times that employment is at will. The progressive discipline and termination process sections of the policy specifically state
You have 1 minute, counsel. 1 minute.
the town may bypass the process of progressive discipline and need not follow the termination process. To be sure that, to make it clear, the policy also radiates that this means that more or less discipline up to and including termination may be imposed in a given situation at the town's sole discretion. With regard to the tortious interference claim, if Mr. Butler claims that the town, the select board member was not acting within the scope of employment, 901A must be construed to create municipal liability only when a municipal employee is acting within the scope of its employment. Otherwise, there'd be liability for everything. And here, Mr. Butler didn't name any individual town employee. Due process claims failed for lack of property interest in employment and because he resigned.
Okay, thank you. Your time has expired. Thank you very much. How much time does the appellant have, please?
48 seconds remaining.
Counsel?
All right, thank you, Your Honor. Dealing with this in reverse order, Section 901A simply doesn't distinguish, 901A and not B doesn't distinguish between what the town is assuming for the liability of a municipal officer. Now, regarding whether there's a dispute over Mr. Butler being forced to resign, when he was in that hearing and he was handed that memo, it said, "You are suspended now. You have committed these violations." And he was told, this is what was decided. It was very clear to him that nothing he could say was going to change the minds of the select board at that point, and that his future was not looking good because the select board had believed another employee over him without checking on the allegations. And so he was looking at more discipline or being terminated at a future date based on mere allegations. So those facts, whether he was forced to resign, are very much in dispute. Also, the fact that the board ignored or rejected all of his requests, and he made 3 during the following 2 weeks to return to his job. And
Okay.
last,
Your time has expired.
okay, thank you.
Thank you very much. Please call a conclusion of the hearing.